Hello friends, Namaskaram. Myself is Dr. Jinesh Soni. I am an advocate and a criminal defense lawyer. Today we are going to discuss the concept of FIR in connection with cases under Prevention of Corruption Act. Please note down all the points in systematic manner. I request all of you to maintain a proper notebook with pen or pencil so that whatever I am going to narrate you could be maintained by you in recorded format. Suppose you are a public servant and you are having a false criminal case against you under Prevention of Corruption Act and you want to contest the said case at your own level. Is it permissible? Answer: yes, it is permissible as per section 32 of Advocate Act. Another point arises: if we are going to contest, what documents are important or material? The important document is FIR. FIR means Pratham Suchna Report or First Information Report. FIR is registered even in cases under PC Act under section 173 of BNSS. Prior to BNSS, it is registered under section 154 of CRPC. So, the concept is now clear. As far as the PC Act is concerned, there is no protocol to register the FIR, and that's why the FIR is registered as per the protocol of section 173 of BNSS. And in case we are having case prior to 1st of July 2024, the FIR would be under section 154 of CRPC. So now the concept regarding the same is also clear to us. Now the important question arises: how to read the FIR and what are the various segments of FIR. As we know that FIR is registered as per the protocol of BNSS, so basically it is inter alia divided in 12 parts. First part means number 1, indicate the district and the name of concerned PS. PS means police station. But in case of CBI trap cases, the concern of PS is used to be kept blank. And apart from that, in column of district, the place and the concerned wing of CBI working on the concerned case is mentioned. In the column of year, the concerned year when the FIR is registered is mentioned. Apart from that, we are having the FIR number and the date on which FIR is registered. So in first capsule or column, we are having the concerned district, we are having the wing of CBI, we are having the year of FIR, we are having the FIR number and the concerned date of the FIR. Now we are coming on column number 2. It deals with the consent act under which the concerned accused is implicated. As we know that PC Act means Prevention of Corruption Act. So it is mentioned, and we might be implicated in section 7 or 8 or 9 or 10 or in all of them. So it is mentioned. Usually in trap cases, section 7 or 7A, 7 or 8, 7 or 12, 7 with the help of 61 subclause 2 of BNS is added. So it is basically a combination. We have to understand. To be noted that if you are having a FIR under section 7 of PC Act, in case the case is confined up to the extent of demand only, in that scenario, even prior to investigation or inquiry or FIR, the compliances of section 17A of PC Act is sine qua non. If there is no compliance, then in absence of non-compliance, the proceeding would vitiate and FIR would be illegal. The said view is approved by the important judgment of Honorable Rajasthan High Court titled as Rani Dahan vs. State of Rajasthan. Judgment date is 8th of October 2024. In addition to this, if there is BNS, they may write BNS also. And apart from that, the column other act and offences is usually kept blank. Now we are coming on column number 3, suspected offence. In that category, a general description is given. For example, you are arraigned as per section 7 of PC Act. It will be mentioned that the concerned public servant is indulged in the activity of demanding undue advantage. And in addition to this, if there is 7A, 8, 12, as I told you earlier, or section 61 of BNS, there might be the averments of criminal conspiracy as well, or abatement as well. So, column number 3 merely indicate the general description of the alleged offense. Column number 3 is very much important because the concerned authority is duly bound to mention the day when the offense had been committed. The period means the date on which the offense is reported and the date on which the operation of concerned offense is ceased is required to be mentioned. In absence of specification, in that scenario, the FIR would be termed as a defective FIR. Apart from that, they have to specify the time. In addition to this, they have to specify when the information had been received at the PS. If all the details are not mentioned, it is compromised. In that scenario, it will be presumed that material facts are compromised. Then we would get the benefit as per norms. Apart from that, in the last column, they have to specify the concerned diary number. It is inter alia concerned with the entry number. It is basically nothing but journal diary, which is called GD. Apart from that, they have to specify the date of entry, have to specify the time of entry. These details are not casual entries. They must be specifically mentioned. In the case, in absence of specification, we could take the benefit. Sometimes it is observed that in multiple FIR, the offense is committed, but prior to that, the concerned authority is having the information, which is not possible. So in that scenario, we could take the benefit. Concerning this, I inter alia updated content which is available on Soni Arena. To be noted that we are having two channels. One is Voice of Defense, other is Soni Arena. If you want to understand the basic contents in Hindi, you may follow Soni Arena. But if you want to understand all these concepts in English, you have to follow Voice of Defense. At point number 4, it is mentioned that in which manner information is received. Usually it is in written format, but sometimes it may be in oral format. But when it is in oral format, the concerned SHO is required to narrate the same in written format. And apart from that, there is a requirement of inquiries so that the facts could be verified from inception. When all the formalities are not done in legal way, in that scenario, FIR would be illegal and we may challenge the FIR on that point as well. At point number 5, there is mentioning of place of occurrence where the offense had been committed, as the offense is concerned with demand. So they have to specify at what place demand is made. The point is important because sometimes there might be a case that multiple times the concerned accused had raised a demand. So in case the place is not specified, in that scenario we could have the benefit. And apart from that, when the first demand was made, they have to specify. And when the matter was reported, they have to specify as per the protocol of section 8 proviso of PC Act. In absence of all this specification, we are having a very good case to contest on merits. So usually it is observed that FIR is not an encyclopedia. Yes, it is correct. But the material facts are to be specified. In case of non-specification, in case of concealment, we could have the benefit. Apart from that, there are certain columns like address, regarding jurisdiction, which is usually not mentioned or filled by the concerned authority. But if it is not filled, then why? Always observe the FIR as if it is a suspected document. because this document is going to be transformed into a charge sheet. So we have to work out on the root cause. If root cause is defective, in that scenario, charge sheet would be defective. After that, the name of complainant is mentioned. Sometimes they mention source, sometimes they mention name of device P, or sometimes they mention name of the complainant. But to be noted that in case the specification is not complete, we may have the benefit. For example, as far as section 7A of PC Act is concerned, for the prosecution of a public servant, it is sine qua non that there is an offer by the concerned complainant and voluntarily acceptance by the accused. In case there is no complainant, then we could have the benefit. So we have to read the FIR more effectively, not from the eyes of our advocate, but from our own eyes. When you have tried your best for job, as per your own conscience and discretion, this time we are going to lose our job. So we have to work out more emphatically, more sincerely, but not in public, but alone. We have to give time to our case, and apart from that, we have to work out on our case in a peaceful manner. And alone is the only remedy to consider the case in a peaceful manner. It is the orthodox pattern of all of you to consult the advocate if you are having a criminal case against you. But the practice is wrong. Do not consult the advocate at inception. Read your case at your own level, find out the errors, and then consult the advocate for expert opinion, not for general opinion. And that's why I am insisting all of you to read your case at your own level, because you are the only person who know how to deal with the case, because you are the master of facts. In that scenario, you could provide the best information which your advocate is not having. So believe on Almighty, believe on yourself, and with the blessings of Almighty, please read the report and FIR. If you are able to understand the basis of FIR, definitely you would be able to understand 50% of your false criminal case. Because FIR is the first document, as I told you earlier, in consequence of which criminal law is set into motion. That's why the document cannot be a casual approach. It must contain the material information. If it is not containing, then we may have the benefit. Wrong information, false information, fabricated information can be a basis for a good contesting defense. So we have to understand all these points. Now we are moving further. Apart from that, usually the consent name of complainant, his date of birth is not specified. Simply it is mentioned NA. Who is NA? Your neighbor or my neighbor? Who is NA? If column is there, you are supposed to fulfill it. If they are putting NA, they are putting no to their own case. Find out the reason why they mention NA. Is this term is recognized under BNSS or under CRPC or under PC Act? From where they have taken this term? From Mars? From Moon? From Sun? From where they have taken? Is CBI or vigilance above the rule of law? Do you think? I want to recall all of you towards the important judgment of Honorable Madras High Court, dated 28th of April 2025, wherein adverse remarks inter alia submitted against CBI working. Do you know or not? You have to update your information on that point as well. I want to clarify that CBI is not God. You are the God of your own fate. And that's why you have to understand the case in the basic route, so that you could easily contest the same after having the proper examination of the same, and doing the examination by a person of his own case at its own level can prevent the prejudice to be occurred in near future. And you are the only person who will take pain in his own case, because no one in this world is available to help you. Even God help those who help themselves. So it is the best time to wake up and to proceed. And I am narrating you the way to proceed. Even Lord Rama has to proceed to find Lourdes Sita. He is the God, he can do anything. Instead of that, directions was taken to proceed. So I request all of you to proceed, but in logical manner, in effective manner, so that you could get the proper way out in your case. In the next column, that is point number 7, definitely we will find the name of concerned accused, and apart from that their full descriptions has to be mentioned. But what we get, a separate sheet is annexed. Oh, the great approach of CBI or vigilance. Despite of mentioning attached separate sheet, they mention. Why? So we have to work out on all this perspective to show that they are not sincere towards their approach. Do you know, in one of the judgment, inter alia propounded by Honorable Allahabad High Court, it is submitted that the fill in the blanks approach is illegal. If you are having the FIR, then it should be in a proper context. The fill in the blanks inter alia indicates non-application of mind. And apart from that, it is indicating that material facts might be concealed or they are not mentioned deliberately to cause prejudice to the concerned accused. So we have to understand the basis of those guidelines as well. Apart from that, we are also having a great point of defense. Reasons for delay in reporting by the complainant. अभियोगी सूचनाकर्ता द्वारा सूचना दिए जाने में विलंब. Do you know, even in love, we are having a cause. Without cause, there cannot be a fire. In multiple judgment, it is observed even by Honorable Supreme Court that there should not be any delay. If delay, it should be explained appropriately. If it is not explained, then we could have the benefit. As per section 8 proviso, the matter is to be reported within 7 days from cause of action. So it will occur when the first demand would be made. So when the first demand is made, is to be specified in the FIR. Are you agree with my submission? If yes, then mention in the comment box. But whether they inter alia incorporate the said fact or not, think twice before proceeding to read the charge sheet. You are inter alia indulged with those facts which are totally out of syllabus. You are reading charge sheet without knowing the FIR. You are surviving without knowing your past, from where you had come. Do not do such foolish practice. You have to find out when the first demand was made, then second demand was made, and when subsequent demands were made, so that we could find a proper cause and the reasons for delay in reporting the matter. And again, if there is no delay, despite of delay, then it is a fabrication. You may lodge the proceeding against the CBI. I know that person would say it is not possible, but I am going to tell you one of the most important case of Honorable Madras High Court, in which one person, Jinesh Prabhakaran, had reported the matter to the concerned High Court, and finally liberty was given to the concerned accused to approach to the concerned authorities for proceedings. In case they fail to do so, then again liberty is given to come to Honorable High Court. If such person can do concerning cases in PCA, then why you cannot? Do you think that he is having a different level of intellectualship you are not having? If he can, then you can also. Because we all are child of Almighty. He entirely blesses us with equal level of intellectual. So please work out and take your case sincerely, not in the casual manner. If you are casual, then everyone is casual with you. In the next point, the consent detail of the property stolen is to be mentioned, but here they have to mention the amount of demand indulged. And apart from that, point number 10 is of no value. Point number 11 is again of no value because it is consent with inquest. And in point number 13, 14, 15, the facts are mentioned concerning the laboratory analysis. But these points are concerned with charge sheet, not with FIR, to be noted. Here we are having the last point, that is the description of FIR. That is called Pratham Suchna Vivran. But in CBI cases, it is registered on the basis of verification report. And while having the same, they usually give the record to the consent complainant with direction, go and have the recording. After that, they verify the consent demand, and after that, a verification report is prepared, and finally, a FIR is registered, which is usually called document number D2 or D1 or D3. So, I think that I am totally able to cause all of you to understand the FIR, its importance, and what columns are to be filled by the concerned authority while proceeding in the case. So, next time when you are going to consider your case, you have to keep all this point in your mind so that you could find out whether it is a fit case for FIR or not. If the allegations are omnibus, concocted, there is no demand, there is no compliance of section 17 of PC8, then you may easily challenge the FIR. And apart from that, there are certain cases wherein there is no public servant, but a private person is indulged in section 7 of PC8. So it is a case of defective or illegal FIR. So all these points are important for our understanding. So see you in the next video. Till then, Jai Hind, Jai Bharat.